Okay.
All right, welcome to our issue class on the First Amendment Religion Clauses, Part 2. We'll give it a couple minutes. It's still not quite 9:15 for those in the building to come into the class. If you're watching online, same as last week, if you want a copy of the packet that everyone here has, just shoot me an email, and I will send you that packet so you can kind of follow through. So last week we discussed Part 1, the Establishment Clause, here at Issues class, and we also talked about the idea of freedom of speech in our timely topics. Now, both these things are kind of coming to a head right now in recent cases, both Supreme Court, immigration courts. We'll see it kind of coming up more here in the next few weeks. We have the immigration case right now of can someone be deported basically for their speech that the government can say is affecting their foreign policy. So that's what's at the crux of this recent immigration case with Khalil Mahmood. Government says, hey, his speech is dangerous to our foreign policy, where his lawyers are saying even immigrants are protected by free speech. The government cannot punish somebody for what they say. We talked about what the limits of that are last week, so keeping track on that, how that plays out, because it has to do with religion to a degree too. As we wait for other people to come, just kind of think about, so right now, today we'll talk about the free exercise of religion. So you have Jewish people worried about their freedom of religion as they might come in with signs of the Jewish faith, the yarmulke or something, and feel like they're being targeted by hate speech or even sometimes violence, saying we can't exercise our religion freely at some of these college campuses. We can't wear this because we get targeted. It's not fair. On the flip side, there might be Muslim students that say, we see what's happening to Palestine at the hands of Jewish people. We are trying to support this, what's happening, basically a genocide of these people. And by supporting them, we're automatically siding with Hamas, and we're being taken away. So we can't exercise our free speech and free religion. And so others might say, well, in doing that, you're really supporting Hamas, a terrorist group. And people are like, well, that's bad. Not that long ago, you had Catholics in this country who might talk about Northern Ireland and say, hey, it's not fair what's happening to the Catholics in Northern Ireland, and end up kind of having sympathy for the IRA, but you didn't have quite such fear around it. So there's all these different things where speech and religion end up tying together, and the exercise of religion. And often the exercise of religion involves speech, which then enters into the free speech clause as well. They're all tied up together. So to recap, last week we talked about how the First Amendment protects religious liberty in two ways. First, it guards against the government establishment of religion, and second, it protects the free exercise of religion. Together, these constitutional promises are at the core of our freedom of conscience, the right to freely believe as we wish. Some people are feeling, okay, now if you might believe something different from the current government, you start getting punished by it. Whether you're a law firm, whether you're a citizen, whether you're an immigrant on a green card, if you suggest something different about foreign policy, there are now ramifications. Does that affect the First Amendment rights? We're going to have to wait and see what this Supreme Court says, and the reality is what future Supreme Courts will say, because the court changes and their interpretations differ, which is why all these rights are somewhat fluid. There isn't one set, this is your freedom of speech, and people argue it, or freedom of religion, because how it's interpreted changes over time. So when you kind of do something, though, it might cause problems, but you might rely on the Bill of Rights, it may not always be there for you in the same way, because it has been interpreted differently at different times. So last week we focused on the Establishment Clause, which disallows the formation of basically a national church. So we don't have a national church and no longer have established churches in the states. What does the Establishment Clause mean today? Well, here are some easy cases. One, virtually all jurists would agree that it would violate the Establishment Clause for the government to require church attendance, right? No one in the government can say, you gotta go to church on Sunday, go to Derry Presbyterian Church. It might help our numbers, but no, anti-constitutional. Or for the government to mess with the religious organization's selection of clergy. They can't say you can have this clergy, you can't have that. Now there are exceptions to the rule. If you say a church wants to bring in somebody that might be deemed a threat or a terrorist or something, they might say, no, this person can't come into the country and be at your church. Two, the government doesn't involve itself in its religious doctrine, or for the government to grant benefits to some religious entities but not others without some legitimate non-religious justification. So you can't give preference to one religion over another. Say a Christian school you get tax money for, but not a Muslim school. I recently met with Scott Perry a while back, and even he agreed with that. He was a proponent of certain bills that kind of asked, well, what about if a Muslim school wanted? He said, yeah, you have to treat it equally. Good to hear. So you can't have some benefits to some religious entities. So again, we talked about the case of the Ten Commandments at a courthouse or something. The Louisiana law says you have to have the Ten Commandments posted in schools. Okay, you might better do that, but they'd have to have some other things there too, and not just the Ten Commandments. So if you had some laws of Muslim or Hindu stuff, and somebody wanted that, it could be challenged, and they say you have to put that up too potentially. Interesting to see what the Supreme Court does on these cases. If you're only giving it to Judeo-Christian and nothing else, that would violate the Establishment Clause. And a lot of times recently, the Supreme Court hasn't cared. And it's interesting that this freedom of religion is kind of moving towards freedom of Judeo-Christian religion, not for others. There is more of a prioritizing of that now than has been in the past. And so to keep an eye on that. But many of the issues around freedom of religion are often hotly contested. It's very often a 5-4 vote. And so again, that's why it can change yearly. People can re-challenge it, and it might be a brand new thing the next time. So these rights aren't spelled out in the Constitution, which gets difficult. Sometimes we wish the Bible would kind of spell things out more clearly. Like, God, give us a whole paragraph on what exactly you mean by this, so we all know and there's no argument. We don't have that in the Bible usually. We don't have that in the Constitution, unfortunately. So today we'll look at the Free Exercise Clause. So from the beginning, courts have struggled to strike a balance between the religious liberty of believers, who often claim the right to be excused from laws that interfere with their religious practices, and the interests of government. How far does my right to practice religion how I want go into laws that the government sets? The Supreme Court has repeatedly said that the government may not compel or punish religious beliefs. In America, people are free to think and believe whatever they please according to the dictates of their conscience. However, the Free Exercise Clause has never provided absolute protection for religiously motivated conduct. For example, the government is allowed to ban behavior that a certain religion requires, like polygamy, that's marrying more than one person, or the use of hallucinogenic drugs. So one reason I say, hey, it's our religion to use these drugs, the government can say, sorry, it's against the law. And other people say, well, now you're violating my First Amendment right. This is where you often have this bounce back. Is it okay to sacrifice humans because your religion says so? Government says no, that's murder. So where it counteracts against a current government's law, the right protection goes away. The court has said the Free Exercise Clause embraces two concepts, freedom to believe and freedom to act. The first is absolute, but in the nature of things, the second cannot be. So that's 1940 case, Camel vs. Connecticut. That's a pretty good way to think about the court's application of the clause over time, and the ongoing debates over how to rule in free exercise clauses. Of course, governments don't usually adopt laws banning or requiring thoughts. You can argue sometimes that's the case, but usually not. Instead, our laws regulate conduct. In other words, actions. And the Free Exercise Clause is used in a variety of legal challenges. One is when the government bans behavior that a person's religion requires. Think polygamy, or animal sacrifice, or the use of hallucinogenic drugs, or even human sacrifice for that matter. But also more interesting things. So, there's actually legal challenges right now, even before the current Trump administration, from Jewish synagogues saying you cannot discriminate against transgender people because in the Jewish faith, there's actually texts and things about that. So you have to be treated equally and they are welcome as part. So they're saying, hey, by us not being able to do this, the government says we can't, you're violating our religious liberty. How that plays out again, if the government says, well, here's the law we're going to create, we're not going to allow that conduct. But you see this happening all the time. Or in the case of a business doesn't want to bake a cake for a same-sex wedding, but the law says same-sex people can't get married. Do you as a private business have a right not to? We see all these different cases. Sometimes the people who don't want to bake the cake win. Sometimes they don't. The case of the Kentucky clerk who didn't want to sign same-sex licenses, where they worked for the government and said they didn't want to. And their challenge was her religion says she shouldn't have to. But working for the government is a privilege, not a right. So there's a difference between you working for the government when you're a private entity. Can the government coerce a private business to do something they don't want to do? But if it advertises, it serves the public. So all these different things mesh together. So there isn't hard and fast rules. So a second is to think about when the government requires conduct that a person's religion bans. So think fighting in a war. We had people who said, I'm a pacifist, I can't be drafted. Often they would run, they'd pretend to have a heel spur or something, or they'd say, I am a conscious objector, and they might work in the civil patrol, some other kind of thing. So, or paying taxes that serve a program that violates religious beliefs. I don't want to pay taxes because your money goes to this. I think every single person could probably make that argument that the government does something with their money that their religion looks down upon, right? Whether that's war, whether that's subsidies, whether that's funding grants of a variety of different scientific things, abortion issues. Everybody could say their tax money goes to something that their religion says you shouldn't affect. Or having to take off your yarmulke or veil. That's a big one right now across the world, especially for Muslims who have the veil, saying you are not allowed to have this mask on in public. Right now they're trying to ban masks at college protests. Turkey wanted people not to wear masks when they said you couldn't protest at all. The people wearing masks with facial recognition couldn't get this, and they could be arrested. It's kind of scary how accurate facial recognition is now, right? Going through global entry, you just walk past a camera, it catches you, and the person says 2 seconds later, you're good to go, Stephen, just from your face. That's a little bit terrifying, but there's another one, like, hey, my religion says I need to cover my face, and the government says you're not allowed to. That's another issue. And third is when individuals claim that laws burden religious observance. So think working on the Sabbath. The Supreme Court first addressed the Free Exercise Clause in a series of cases involving 19th century laws aimed at suppressing the practice of polygamy by the members of the Church of Jesus Christ of Latter-day Saints, also known as Mormons. The court unanimously rejected free exercise challenges to these anti-polygamy laws, holding the Free Exercise Clause protects beliefs but not conduct. So a quote from that case, laws are made for the government of actions, and while they cannot interfere with mere religious beliefs and opinions, they may with practices. The Supreme Court warned that to rule otherwise in a case like Reynolds would be to make the professed doctrines of religious belief superior to the law of the land and in effect permit every citizen to become a law unto himself. That makes sense, right? Yeah. If every religion can just say, here's what our religion believes, we don't have to do this, that would basically create no laws. There's that. On the flip side, just to kind of play devil's advocate with the Supreme Court, if you say you have freedom of religion, what's their rationale for not allowing polygamy that somehow affects the larger things, just because that's our idea of what's right and wrong at the moment? And so why is that the idea? Does that idea of monogamy come from a particular religious philosophy at the time? Thus, you're actually prioritizing one religion's ethics over another. Does polygamy actually hurt others and cause larger national crisis? Or is it because we've defined for ourselves what is morally acceptable at any time, and thus created that standard. And then you have to go back and search, why is that the current modern ethic? And that changes over time. Does that prioritize one religion over another? These are all the fun questions to ask yourself. So in some ways, yeah, you can't have every religion being like, you know what? My religion is to go as fast as I want on the highway. It's my religion. Well, that can obviously be a safety issue that affects others. But some things are deemed illegal that actually doesn't hurt anyone else. But we said it's immoral. Why have we decided it's immoral? That's a fun question of where do we get the idea of common ethic? It's a whole other class we should do sometimes. Where do we get our ethics? What's the basis of moral philosophy? So what followed this case was one of the most extreme government assaults on religious freedom in American history. Hundreds of church leaders were jailed, rank-and-file Mormons were deprived of their right to vote, and Congress dissolved the LDS Church and took away most of its property until the church finally agreed to abandon polygamy. So this is in the late 19th century, right? And the government is disbanding a church for its beliefs. So we think America's always had freedom of religion, government stays out. That's a myth. Government often gets involved way more than it should. Again, it's polygamy. And they said, we are shutting down your church and jailing your clergy over this key part of your religious belief. And the Supreme Court sided with it. So, what's to say at some point the government can say, something that Presbyterians do we don't really like. And we're going to shut your church down until you stop. It's not unheard of. Going off the page here, because I might have more time, a fun fact. Just talk about Pliny the Younger. So Pliny the Younger, in Rome, he's sent by the emperor to kind of deal with checking out what are Christians, what are they doing, are they a threat to the government? Because you have this larger Christian groups kind of being in the Roman Empire, they're growing in Greece and all these places, and the emperor's like, are they going to cause a problem? Because Rome has its own imperial religion at the time, Caesar's emperor, but for the most part, they don't care that much, it doesn't affect their power. So Pliny was sent to these places in Asia Minor and Greece to kind of check it out. And he kind of wrote back, we have the letters actually, he says, they gather on the first day of the week, and they pray, and they read some stuff. It's fine, it's boring, sermons are the worst, all that. But then he says, here's the problem. They have a meal together. And it's the rich, and it's the poor, it's the slave, and it's the free. And they all bring something, and they eat as equals. And that can undermine how we order society. So basically he said these potlucks are prohibited. Could the government ever be like, they meet too much. And they gather, and everybody's equal, and they all bring something to share, and that worries us. Could they prohibit potlucks? It seems outlandish, but there's no reason they couldn't. The government anytime can create a law, if it creates the law, and the church would have to follow it, or they can disband it. So freedom of religion is not absolute. At any time the government can create a law and say, you can't have potlucks anymore. Music is a way to protest or a way to inspire people. We don't want that. No more music in church. You would think that's against doctrine, but there's precedent for the government creating a law that they think, for whatever reason, is moral or good or bad, and the religion would have to follow it. So the freedom of religion is not as absolute as we think. As the case, the Mormons had their entire church disbanded when they thought they were protected by the First Amendment. That makes sense?
Yep.
All right, so Reynolds, this case, influenced the meaning of the Free Exercise Clause well into the 20th century. So in 1940, the court finally extended the clause to limit state laws and other state actions that burden religious exercise. Again, this is kind of the incorporation stuff in this Cantwell 1940 Act. In the 60s and early 70s, the court shifted on religious liberty claims, strengthening protection for religious conduct by reading the Free Exercise Clause to protect a right of religious believers to exemption from generally applicable laws which burden religious exercise. So again, you have these shifts back and forth of lots of freedom, no freedom. So for instance, one case was Sherbert versus Werner. So basically, good ice cream versus a dude. So their estate denied unemployment benefits to a woman, a member of the Seventh-day Adventist Church, who quit her job rather than work on her Saturday Sabbath. The Supreme Court applied its toughest legal test in this case and concluded the denial of benefits imposed substantial burden on her religion. The woman had to choose between her income and her faith. For the core of the issue was, quote, whether some compelling state interest enforcing the eligibility provisions of the statute justifies the substantial infringement of appellate's First Amendment right. The court said no and concluded that the denial of benefits constituted a violation of the Free Exercise Clause. If that case was tried today, I think it'd be reversed based on the current Supreme Court. It's not tried again today, but back in the 70s, it said, okay, this woman, Seventh-day Adventist, you don't work this day, her job's requiring it, that provides undue burden on her. Today it might be like, well, you chose to have that job. But there are many jobs where you have to kind of work, and there are limited jobs, so if you have a certain religion, that could completely affect your ability to work. Thus, you have to choose between your religion and being able to live. And the court at that time said that violates the Free Exercise Clause. If that keeps you, but there are probably limits. If somebody says, my religion says I can't ever work. I have to just sit at Jesus' feet like Martha and pray, and Mary and pray. That's my religion. Then I'd be like, sorry, you have to. But maybe not, because there are Orthodox Jews in Israel who don't have to do any job. They just serve, and the government pays for them. Guess where the government gets that money? Our government. Our government pays Israel to let Orthodox Jews not work and just have faith. So again, prioritizing a religion. How do people do that one? So that's always these issues. We see a similar approach in the case of Wisconsin versus Yoder. There the court concluded that Amish families could not be punished for refusing to send their children to school beyond the age of 14. The court reasoned the Amish objection to formal education beyond the 8th grade is firmly grounded in their religious concepts. They object to high school and higher education generally because the values they teach are in marked variance with Amish values and the Amish way of life. They view secondary school education as an impermissible exposure of their children to a worldly influence in conflict with their beliefs. The court added, the record in this case abundantly supports the claim that the traditional way of life of the Amish is not merely a matter of personal preference, but one of deep religious conviction shared by an organized group and intimately related to daily living. The court concluded, the impact of the compulsory attendance law on respondents' practice of the Amish religion is not only severe, but inescapable, for the Wisconsin law firmly compels them under threat of criminal action to perform acts undeniably at odds with their religious belief. And so, in the self-sufficient nature of Amish society made education for 14 and 15-year-old children unnecessary, and the 2 additional years of compulsory education, quote, will not impair the physical or mental health of the child or result in an inability to be self-supporting or to discharge the duties and responsibilities of citizenship or in any other way materially detract from the welfare of society. So the court concluded that there was a constitutional violation. We're a long way from Reynolds, right? But then a weird thing happened. The court backtracked. So back to the Amish case, they have saying, okay, Amish generally is well known, their religious beliefs, not having school at a later time because the kids get kind of more taught about worldly issues. So now you get taught about these issues when you're in 2nd grade, so I guess they can't send their children to school at all because things are happening so much earlier. But the court could look at this and say, okay, there's a long history of this. Where if somebody kind of said, made up a new religion, the court's going to be like, is it though? So the Amish could demonstrate over a period of time that this is part of the religion, this is how it works, children still are able to lead a good life without that schooling. So the court said, hey, this law that compels school should not apply to the Amish because it affects their religious liberty. What you can see interesting now is we have cases coming where different religious groups can say, we don't like these books read in school because our children are subjected to things they don't agree with. Now, if you start doing that, though, every religion can say everything we teach in some ways goes against my religious belief. Oh, I don't like this book about this. Well, I don't like this book about that. And I don't like that we're teaching this or that or the other thing. So it can go down the slippery slope argument real fast. So the court backtracked after this 1972 case. Although the court's legal test did not change, the Supreme Court denied far more religious liberty claims than they granted after the 70s. For the most part, these cases follow a familiar pattern. A law applied to everyone in a given jurisdiction. Someone came to court and claimed a religious objection to the law, and the court ultimately rejected the challenger's claims. So there's a big period there where most religious liberty challenges were getting denied. The bottom line, whether you were an Amish employer refusing to pay Social Security taxes or an Army doctor wishing to wear a yarmulke while on duty, you were probably going to lose your constitutional claim under the Free Exercise Clause. Those are real examples. So you'd think, okay, soldier, yarmulke, no, that's not the free exercise of religion. Then along came Employment Division v. Smith in 1990. I love all these names of Supreme Court cases. So that's a landmark decision that read the Free Exercise Clause very narrowly. The case involved Native Americans dismissed from their jobs for failing a drug test. They had smoked peyote during a religious ceremony. Because of this drug use, religiously motivated or not, Oregon then denied them unemployment benefits. When they challenged this action on free exercise ground, the Supreme Court rejected their claim. However, rather than simply applying the court's usual test, Justice Scalia, writing for the majority, traded the traditional test for a clearer rule that was even less protective of religious objectors. Scalia wrote, the Free Exercise Clause, quote, does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability on the ground the law prescribes or prescribes conduct that his religion prescribes or proscribes. So basically, Scalia now has created a new rule that if the government has a basically neutral law applied to everyone, and your religion either kind of goes against that, or says you can't do that, tough cookies. So again, if the government said people cannot have potlucks, church cannot do potluck. If they said you cannot have more than 50 people sing a song together, sorry, church can't sing the song anymore. If it says, I don't know, whatever else, you cannot baptize infants, or you cannot, in general, you cannot in a ceremony put water on a child's head in the gathering of 2 or more, tough cookies. If it's applied to everybody, that's what this new claim would basically suggest. Kathy?
But that law would have had to have been made already. I mean, like in this case, it seems like Scalia wrote that because it was drug use, and which was a law already there. They couldn't just, at this point, say, okay, we're going to ban potlucks, and so you can't do it.
Yeah, you could do it now, and then if we try to challenge it later, they couldn't get it something that happened like, well, 3 years ago you had a potluck, and now there's a new law. No, but if we tried to have a potluck after that law, then they could get you. So he's basically saying it doesn't matter if there's a law that's not specifically targeted at a religion, so it's kind of a neutral law applied to everybody that goes against your religion, tough cookies, basically. So very narrowing the Free Exercise Clause. Scalia echoed Reynolds' concern that religious exemptions permit a person, by virtue of his beliefs, to become a law unto himself, contradicting both constitutional tradition and common sense. Any religious exceptions to general laws, therefore, must come from the political process. So basically, if you have a challenge, it needs to then change the law. So you can see the wisdom of that and the error of that. The wisdom is it can become crazy if everybody creates their religion and has their own set of rules, right? If every group has an exception, that can become problematic. That's a slippery slope. On the flip side, there are real issues of long-standing religious traditions that can be circumvented by laws that do not allow you to fully embrace your religious beliefs, whether you're Jewish, Christian, Muslim, Hindu, or whatever. It's tricky to have religions that have their own laws and rules coincide with a nation state that has their own rules and laws, especially if you're a pluralistic religious society, because then you have several different groups that have their own rules and laws. Think about all the religions in the world and all the religions in this country. If you did have all these exceptions, you'd have so many different rules of law. On the flip side, we talk about founding and having these free religious clauses that aren't really able to be lived out. And this is where this balance and tension is often very difficult, because it's so easy to go too far one way and really limit people's exercise of religion, and on the other way of laws don't make any difference because everybody has their own law. It's on a knife edge, and it's hard. Nevertheless, Smith, this case, proved to be controversial, and Congress responded to Scalia's decision by passing a new law countering it. In 1993, overwhelming bipartisan, I missed that word, majorities in Congress passed the Religious Freedom Restoration Act, which was signed by President Bill Clinton. This law was meant to restore old protections for religious dissenters, as in the former protections that they had before the Smith case. RFRA allows courts to exempt a person from any law that imposes a substantial burden on sincere religious beliefs or actions, unless the government can show that the law is the least restrictive means of furthering a compelling government issue. So it's also a tough legal test, and it hasn't really been used very much. And it's very easy then for the government to say. It isn't the case of the current Palestinian protester person. All the evidence is the Secretary of State saying this creates a challenge for our foreign policy and issue, and that ends the case. So while you might have that law, it's very hard to pass the test because the government can make the argument whatever it wants to. People haven't used it. Congress then passed another law, the Religious Land Use and Institutionalized Persons Act, which applies the same tough test as state laws affecting prisoners and land use. These new laws have led to exemptions in a wide range of contexts, from kosher and halal diets to prisoners, to relief from zoning and landmark regulations on churches and ministries, to exemptions from jury service. Although some exemption claims brought under these religious freedom statutes have been relatively uncontroversial, for instance, the Supreme Court unanimously protected the right of a tiny religious sect to use a hallucinogenic drug banned by federal law, and the right of a Muslim prisoner to wear a half-inch beard banned by state prison rules. Some involve highly contested moral questions. So, for example, the court, by a 5-4 vote, excused a commercial family-owned corporation from complying with the Affordable Cares Act contraception mandate. That's the Burwell versus Hobby Lobby stores in 2014. And following Hobby Lobby and Obergefell, we see new legal flashpoints and conflicts over whether businesses with religious objections may refuse their products and services to same-sex weddings. Finally, even after Smith, the Free Exercise Clause itself continues to provide protection for believers against burdens on religious exercise from laws that target religious practices for discriminatory treatment. For example, in the Church of the Lukami Babaluai Incorporated versus City of Hialeah, 1993, the court unanimously struck down a local law against the unnecessary killing of animals in ritual or ceremony. This law was directed against the Santeria religion, which uses animal sacrifice as one of its principal forms of worship. After the Santeria said that they were going to set up shop in a Florida city, that city passed a new law prohibiting animal sacrifice, defined as killing animals not for primary purpose of food consumption. The law only applied to an individual of a group that kills, slaughters, or sacrifices animals for any type of ritual, regardless of whether or not the flesh or the blood of the animal is to be consumed. The Supreme Court struck down that law. The court said that Smith was still a good law, but added that Smith's easy-to-pass test didn't apply in a case like this one, when a law was drawn to apply only to a small, unpopular religious sect. In that case, the court would apply a much tougher legal test, in fact, its toughest one. So with Lukumi, the court wrote a strong anti-discrimination principle into the free exercise law. So if they know that, hey, this law is being targeted, again, what Scalia wrote was general law, it covered everybody. This law was clearly put to affect one religious sect, therefore not okay. In its analysis, the court looked to the text of the law, which spoke of sacrifice and ritual, and considered it in context, namely, that was likely to have been directed at the Santerias, and that exceptions were written in for kosher butchers and other non-religious animal killings. So it was clear the law was targeting a religious group. In the court's view, the law, unlike the one in Smith, was not neutral. The goal was to suppress a particular religion, and the court struck it down. The religion clauses remain among the most hotly contested and debated areas of constitutional law at the Supreme Court. We see some come up every year, whether it's dealing with abortion access. Both sides come up. You have religious claims that it should be allowed because it's a free exercise of religion, and it shouldn't be allowed, or shouldn't be supported because of the free exercise of religion. Religion cases come to Supreme Court in droves every year. For instance, somewhat recently in Espinoza versus the Montana Department of Revenue, the Supreme Court struck down Montana's no aid provision, which prevented religious schools and religious parents from receiving public benefits because of the religious nature of the school. The court ruled this is a violation of the free exercise clause. In 2015, the state created a tax credit scholarship system for students to attend private schools called Big Sky Scholarships. The state directed the program to be administered under the limits of the state's constitution's no aid provision. The provision had its basis in the late 19th century Blaine amendments, a movement against Catholic schools. The amendment nearly passed Congress in the 1870s and would have banned aid to sectarian schools, a word widely understood to refer to as Catholic private schools. Because again, remember, back in the 19th century, the main scary religion out there that we didn't like was Catholics. Now it's moved on to other things. There's always some religious group that the majority is like, that one's not a little weird. Let's keep them from having too much. So, the Free Exercise Clause protects religious observers against unequal treatment and against laws that impose special disabilities on the basis of religious status. So status-based discrimination, punishing the free exercise of religion by disqualifying the religious from government aid, gets the strictest scrutiny from the court. Now, again, it'd be interesting at some point if a Muslim private school made the same challenge. Because often right now it goes to Christian schools of some kinds, but there are private Muslim schools. There was one created in Peoria right down the road from my church that we partnered with on a bunch of stuff. You know, would they get the same scholarships if Illinois had such a thing? The court concluded that while states need not give money to private education, once they do, they cannot discriminate solely on the basis of religious belief. So if Pennsylvania says, you know what, we will give taxpayer dollars to private charter schools or something, then if you're a Christian school, you can apply. If you're a Muslim school, you can apply. Now, you don't have to give money to private schools at all, but once you do, you cannot say just to secular schools. It has to be across the board. The court said that this situation was different from Smith because it concerns government interference with an internal church decision that affects the faith and mission of the church itself. And recently, in Our Lady of Guadalupe versus Morrissey Borough, the court held that the ministerial exception prohibited employment discrimination lawsuits for teachers who were not ordained ministers but were engaged in religious instruction. Today, it remains unclear whether cases like Lukumi and Hosanna Tabor are narrow exceptions to Smith or foreshadow yet another shift towards a more religious liberty protective approach to the Free Exercise Clause. In the last few years, multiple justices called on the court to reconsider Smith. So you might be seeing another shift now. Right now in the court, you see a lot more religious liberty cases being approved from what I call more evangelical Christian circles. So whether it's baking a cake for the same-sex marriage or something else like that. It's interesting though, because you start getting to some of the cases with people claiming kind of Muslim affection, those don't get as much play. So in their religious freedom, is it actually still kind of prioritizing or giving preference to one religion that gets the freedom? As I often hear things about religious liberty, but it's often religious liberty to a narrow group of people. It's like, oh, we should get to put our 10 Commandments up. We should get to have Christian songs in schools. Okay, fine. But then you also have to have Muslim songs in schools. Kind of think about it. I one time did this kind of thing of taking like lyrics from like some Christian songs and kind of saying, like, change a couple words and say that these are some Muslim songs. Like, oh no, we can't have those in schools. Like, actually, they're Christian songs that are in schools. Because we talk about the blood of Jesus and the slain lamb. It can be kind of violent, gory imaging. So these kind of questions of, would we allow prayer from other religions in school, at these games, etc. Because we often, again, what is our cultural feeling of okayness, right? How ethics work, what we feel is okay and not okay, we often almost subconsciously have an idea about, even if we're not religious. There are lots of people who don't go to church, but whether they realize it or not, their values are tied to a brand of Christianity. Like, I know lots of people who maybe grew up in the South and they don't ever go to church, but just the way they talk, they don't realize that it's so influenced by the Southern Baptist kind of philosophy ethic that they grew up with. And they don't even realize it, but it's there. So that can affect the larger kind of national ethic, so to speak. So there's still a lot of cases to come up, and the Supreme Court changes. So we might say we have freedom of religion, but it's not total, and it's not guaranteed at any given time, because how you interpret it might be different from how the court interprets it. Lots of people have thought they were going to be able to do something because of freedom of religion, and the courts or the state or the law enforcement said, no, you can't. And they're like, aha, but I've got this Bill of Rights. And they're like, but we interpret it different than you, so tough cookies. So it's not as clear or as overwhelming protective. Same as free speech. Free speech changes over the years. And all people say is free speech is not necessarily free speech protected by the Constitution. And something that should be protected by the Constitution hasn't been. So the Bill of Rights, like everything in the government, is only as good as its current use and protection. Everything is like, you think about the way government works is that we decide to let each branch of government have equality. But, the judicial branch has no army. So at any time, the executive legislative branch could be like, we don't like the courts anymore. We can overthrow them. It only ever works by everybody agreeing to playing by these rules. And it has worked for almost 250 years, but it's never guaranteed to work because it's all a trust thing. Like money. Money has value because we decide it has money. If everybody decided the dollar had no value anymore, the dollar would have no value. Government and democracy only works because we choose to allow it to work. And the people in power choose to allow it to work. Questions on the freedom of religion? We got a few minutes for questions. Yes, Jack?
The free exercise clause, how would it affect satanic cults?
And again, everything's in context. Depends on what they're doing and what the laws of that area are. So there have been cases challenged and won by satanic cults to say, hey, we are being unfairly excluded. Or they'll challenge it in something that says that prioritizes a Christian thing, and they say, hey, this is establishing this religion, so if you have this, satanic cult should get to have this. And they've won at times. So it all depends on what they're doing. Now, if the satanic cult is going out and hurting people, doesn't work. But you can have, so like, let's say a satanic cult in Hershey wanted to create a building of worship. And the township's like, no, we don't want to give you zoning for that. and they tried to create these laws now that wouldn't allow it. Like, you can't have this kind of symbol or something. In theory, they should be able to challenge that and win, as in that Santeria case. But the Supreme Court doesn't always play fair either. So you never know. But in theory, a satanic cult should be able to do whatever they want as long as it doesn't break currently existing laws that affect others. Or if it does, they can show that this does inhibit their religious beliefs. It's not just something they made up, but here's the long-standing practice of Satanism, and this law unfairly targets them or doesn't allow them to fully do that. It doesn't hurt anybody else. Like in the case of the Amish, they could show, hey, we don't want these 14-year-olds to go to school. We can show over the period of generations that in our system, everything still works out fine. The Supreme Court granted it. So again, it's never a blanket. It kind of depends completely on the context and what they're doing. But satanic cults have won cases at the district or federal level over free exercise clause or the establishment clause of other places.
Did they ever have tax advantages like churches can have tax advantages?
So that was one of the interesting ones. So I believe it was a satanic cult that challenged like the ministerial tax exemption to like housing allowance. It said, well, our satanic temple people don't get housing allowance things. And so the federal district court in Michigan and Wisconsin actually ruled in their favor. And so it was going to be that clergy in that area would no longer get tax exemptions for housing allowance. But then another court stepped in, didn't say they lost the case, but had another, often the courts have these like workarounds, like, well, we're going to still do this, but it's not about the case, about something else. So it's still there. They've often challenged that we don't get tax exemptions for certain things, but sometimes they do. It again depends on how they set up their religion. So it's probably all different depending on which satanic cult. And I haven't done enough research on satanic cults and temples to know all the religious tax breaks. I could try to look it up, but I don't have it currently off the top of my head, all the rules around satanic temples. But often those are the groups that will challenge these other laws, saying, well, they get to pray at the 50-yard line to Jesus, why can't we pray to Satan? And oftentimes, like, we don't want you to. And that's reason enough, which isn't reason enough, but ends up being reason enough. Yeah.
But what you're saying is, as long you can do what you want, and as long as someone doesn't report you, you'll probably get away with it. And if you don't ask for permission, you can get away with it. Don't ask for permission.
Often is the case, asking forgiveness, not permission, is a thing people often do. If you fly under the radar, it's when you kind of become too big. So the church, we travel with majority of people in our Greece trip from this Catholic church, right? 26 of them. They were telling us that they got sued for $4,000 for kind of copyright infringement for not having the right copyright stuff. Kathy, listen to this. Like, we have trouble all the time, like streaming stuff. So it wasn't a freedom of exercise religion things, but sometimes if you get too big, it's noticed. So there was this thing in Illinois, they had this Spoon River Drive big thing. And one church sold apple dumplings, and they called themselves the Apple Dumpling Gang. Well, they got some news, and boom, Disney was like, cease and desist. Here's this little church that's trying to sell apple pie dumplings, but they got heard about, and Disney said, no, Apple Dumpling Gang is our intellectual property. So yeah, sometimes it's, if people don't know about it, you'll be fine. Once people know about it, somebody can get you one way or the other. Somebody eventually complains. There are lots of things happening in schools around the country that if somebody decides to complain, it could be an issue. Or somebody gets fired for a reason and says, I don't think this is right, and they don't take it, it could be an issue. You just never know until it's tried out. There are all kinds of things happening that probably shouldn't be allowed, whether on either side of it. Like, well, you fired this person because they wanted to share this. and they probably shouldn't have, or you're forcing this on kids or whatnot. I always think it's probably an interesting case requiring the Pledge of Allegiance in schools. You know, in a lot of religions, like, you do not pledge allegiance to anything but God, and to force a kid to do that. So a lot of schools now are like, well, you don't have to say it. You just have to stand up. Because there have been times you can't force a kid to say a nationalistic mantra because it can be against their religion. You just have to be able to listen to it and just not say anything. So there's things like that all the time too. But some people still have prayer in school. And sometimes it's challenged, sometimes it's not. And it's different. It's awarded and ruled different ways, different times. Charlie.
What constitutes a religion?
That's the other interesting thing in the Supreme Court. And I think that actually, in one of the cases, they kind of spelled it out at one point. That's a whole large debate in religious studies. Like, what is a religion? Sometimes Buddhism is considered religion. Sometimes it's not. It's more of a way of life. It's just how broadly, how narrowly, and that's often at the crux of things. With the Supreme Court, mostly, they're going to say it has to have an established system of beliefs, worship, larger kind of organizational principles. And for them, it's often going to be like, does it have is it a brand new thing? And you have to prove yourself for a while, probably. Because I can't just make up religion and then break all these laws. It's just like, okay, it seems like you're just trying to do this. So you're just going to have a number of followers, a system, liturgy, a history, a practice, and all of that. So for U.S. government purposes, Buddhism would probably be a religion. For the scholars' purposes, it's going to, depending on the scholar, and you can make a claim both ways, whether Buddhism is a religion or not. You can be a Christian Buddhist, actually. I had professors who were. You can be Hindu Buddhists. There are a lot of Hindus. Like Nepal is mostly Hindu Buddhist. Because Buddhism is more about the philosophy and way you live and less about a deity. So you can follow the teachings of Jesus while still following the Eightfold Path of Buddha. So Christian Buddhist. I had a professor who described himself as a Christian Buddhist. Kathy.
I found it interesting over these discussions, the fact that the cases are in opposition to one another, because I always thought that when we went before the Supreme Court, the attorneys are looking for precedent to present to the court to say this is how this part of the Constitution has been interpreted. And I get that interpretations change over social construct as well. But, where does precedent come in? This was already decided, this is the way we're doing it.
Precedent is always a factor, but never a limiter. So it's like in the Presbyterian Church, right? We have precedents of certain things over the course of hundreds of years, but we're also free to move as the Spirit wills. Precedent was women don't serve as pastors, but we overruled precedent. So new information, new interpretation. So precedent should always be considered, and because you want to learn from the past, and you want to have some standards, but precedent doesn't bind you either. Just like a session, we might say, precedent is for this and this, but you know what? Now we think this is not the way to go, right? We always gave this group free use of the building, but with our new building policy and the amount of money they make, we should probably change that. They might say, well, precedent was, and we might say, yeah, but new situations dictate because we have new equipment, it's costing more for us to run it, so we consider precedent, but we aren't bound by precedent. And the Supreme Court's the same way. They consider it, but they often switch it. And sometimes they're like, we think these other people are wrong. Like Dred Scott decision was a really bad decision. And the Supreme Court overturned that kind of thing. Saying, you know what? Black people are not full people. They said, that's not a good precedent. We're gonna reverse that. So sometimes you want the Supreme Court to be like, this was a really bad decision, bad precedent. We need to flip it. Other times, depending on your personal beliefs, they got rid of a precedent we really liked. And others like, yes, fine, that was a bad precedent. So it's, again, depending on your personal philosophy on whether the precedent was a good one or a bad one. And some of the cases that we might like probably still would have been a bad precedent because it probably wasn't a good ruling in the first place. There's things that, like, personally I really like, you know, I like the tax exemption for clergy, but I could see, you know, some of these cases, like, actually, probably shouldn't be allowed. If I'm being honest and looking at the larger government or free exercise religion clause, it's sketchy. I enjoy it, but it's sketchy. So, there's that. Last question, I have to go to church.
Khalil case, that the lawyers speak took that to an effect of U.S. policy as opposed to his leadership against the ability of the Jewish students to attend school. I can see the argument where his leadership was opposing the Jewish students attending school. I don't see how any of that affected U.S. policy.
It's interesting, and I don't think we'll know for long because so much of it hasn't been put out, you know? So as well, they say, like, we don't have all the information, it's hard to make the full judgment. What their lawyers are hoping to have in New Jersey case is actually get to depose Secretary Rubio to actually get some information. Okay, how is this? Because their big point is, if the government can kind of put out an amendment that says this damages our foreign response to anybody, that's a scary place to be because you don't actually have due process. So I think Khalil's lawyers are right. He is not being afforded due process under the Constitution. And to have this kind of trial, I think it'd be interesting, like you said, on the sense of had his leadership resulted in harm to physical persons or property, which some of it had, and you can say, well, how does the leadership affect? Because the Supreme Court also said, you know, Trump didn't provide the leadership for January 6th, those who acted on their own, so you have to apply the same thing to the protesters. He's not actually doing it, and he's not saying to go hurt these people. You can't hold him liable for leading the mob if he's not saying go actually do this, because again, they set the precedent and said that doesn't count in the case of January 6th and Trump. So that may be why they're not going that route, because that would undermine their administration's argument on some of these other cases. I don't know, though, I'm not in that room, but it would make sense if you're trying to say somebody's leading a group and those people act badly, that reflects differently on all the January 6 cases. That might be why they're going a different route. But it is just concerning to say we think this could undermine government policy, that it limits free speech. If anybody's speech, they can undermine government policy, then you can be arrested. So there's a lot of things right now going on, several big cases around that, with like law firms saying you can't work government cases anymore because you one time defended somebody we didn't like. So right now it's interesting, one of the biggest conservative legal scholars and people who tried a bunch of conservative cases with the Supreme Court has now signed on to defend these liberal law firms. And a lot of conservative and liberal jurists are signed on to it because they're like, this is a bad road to go down on how we deal with legal things. So that'll be interesting to see how that plays out as well. All right, thank you all very much.
Pardon?
You get my email.
Yeah.